Hi and welcome back to my channel. Today we will look at the Criminal Procedure Code under Section 89, which is on complaints and institution of proceedings. So how does one make a complaint? Okay, that is what we will look at under this topic. We'll look at the issuance of summons or warrant. We'll also look at processes which compel the appearance of the accused person. We'll look at service of summons. We'll look at the form and content of summons. We'll look at summons when a person cannot be found. Okay. We shall look at process when service cannot be effected. We will look at service on servant of government, service on company, service outside local limits of jurisdiction, proof of service when serving officer is not present, power to dispense with personal attendance of the accused person, warrant after issue of summons, warrant on disobedience of summons, form, contents, and duration of warrant, court direction when security is to be taken, warrants, generally warrants directed to landholders, execution of warrant directed to police officer, notification of substance of warrant, person arrested who has to appear before the court without delay. We'll look at where a warrant may be executed, forwarding of warrants for execution outside the jurisdiction. We'll look at warrant directed to police officer for execution outside jurisdiction, the procedure of arresting a person outside the jurisdiction, and irregularities in warrant. Okay. So apart from that, we will also look at some miscellaneous provisions regarding these processes, such as the power to take bond for appearance, arrest for breach of bond, power of court to order prisoner to be brought before it, provisions, the general provisions applicable to summonses and warrants. And once we are done with this, if we still have the time, we are going to look at such warrants, okay, and everything about provisions related to bail. Okay, so this is, I'm gonna refer to the Criminal Procedure Code. This is the procedural source of law, as far as criminal procedure is concerned in the Kenyan courts. Okay, so it's very important that we look at this. We look at this with enthusiasm, today's topic. All right, so let's begin. Institution of proceedings and making of complaint. That is Section 89 of the Code. Complaint and charge. Now, subsection 1 says proceedings may be instituted either by the making of a complaint or by the bringing before a magistrate of a person who has been arrested without warrant. Okay, so either how do criminal proceedings begin? This happens either through the police by making a complaint to the police, okay, or by bringing before the magistrate a person who has been arrested with a cognizable offense. That is an offense that you can arrest without warrant. Now, subsection 2, a person who believes from a reasonable and probable cause that an offense has been committed by another person may make a complaint thereof to a magistrate having jurisdiction. So the complaint is not only to the police. In this case, it can be made directly to a magistrate. A complaint may be made orally or in writing, but if made orally shall be reduced to writing by the magistrate, and in either case shall be signed by the complainant and the magistrate. So it has to be reduced to writing if it was made orally, okay, and it has to be executed or signed by the magistrate as well as the complainant. The magistrate, upon receiving a complaint or where an accused person has been arrested without a warrant is brought before him, shall, subject to the provisions of subsection 5, draw up or cause to be drawn up, and shall sign a formal charge containing a statement of the offense, all right, which the accused is charged, unless the charge is signed and presented by a police officer. All right, so where a complaint is made to the magistrate directly, not through the police, the magistrate shall cause a charge to be drawn up, okay? And this charge will indicate the statement of offense, all right? What the particulars of the charge, the offense that is being, that has to be answered by the accused, okay? All right. Now, moving on to subsection 5, where the magistrate is of the opinion that a complaint or formal charge made or presented under this section does not disclose an offense, the magistrate shall make an order refusing to admit the complaint or formal charge and shall record his reasons for the order. So we see it's very important. We'll look at this in depth when we are looking at charges and the rules for drafting them. But we see already here that a charge has to disclose the cause of complaint or offense, all right? Just like in pleadings under the civil procedure, where if a plaint or if any pleading does not disclose the cause of action, it can be struck out on application by the party, okay? The same way here, where a charge does not disclose the cause of complaint, then it is dismissible. It can be set aside, it can be refused to be admitted, and the magistrate will give the reasons for that or for the refusal. Now we move on. The issue of summons or warrants, that is section 90 of the code, subsection 1. Upon receiving a complaint and having signed the charge in accordance with section 89, the magistrate may issue either a summons or a warrant to compel the attendance of the accused. A warrant where the accused is arrested or apprehended and brought before the court, arraigned before the court, or a summons where he is required to make appearance, okay, to answer for the offense that is alleged to have been committed by him, okay. Provided that a warrant shall not be issued in the first instance unless the complaint has been made upon oath, either by the complainant or by a witness or witnesses. So the issuance of a warrant is based on the condition that if it is issued, the complaint, the informant or the one who complained to the who made the complaint about a person, okay, suspected of committing this crime, must have been examined upon oath when he is delivering the complaint, okay. So only if that happens will a warrant be issued as the first go to modus operandi by the magistrate. So we move on to subsection 2. The validity of proceedings taken in pursuance of a complaint or charge shall not be affected either by a defeat either by a defect in the complaint or charge, or by the fact that a summons or warrant was issued without a complaint or a charge. So validity of proceedings, this is now the this is compared to the oxygen principles in the civil procedure, where technicalities as to form should not be a bar to the proceedings, okay, should not invalidate proceedings or block the process of justice from taking place. So the validity of proceedings when it comes to the complaint or charge will not be affected by a defect in either of them, all right? Or by the fact that the summons or warrant was issued without the charge or complaint. Now, a summons or warrant may be issued on a Sunday. So Sunday is the holiday, all right? Is a public holiday, but still we see that a summons or a warrant can be issued on a Sunday. So processes to compel the appearance of accused persons. Now under section 91, we look at summons, what they are, the form and contents, their service, and so on. So what are these processes that are used to make the accused person appear before the court to answer for any charge that is or any complaint that has been given in their name? So subsection 1 says, every summons issued by a court under this code shall be in writing. So we see that the requirement to write the summons or anything really, we will see that it's very important to have the summons to be in writing, in duplicate, so it will be in writing. It will also be in 2 copies, okay, 2 original copies, signed and sealed by the presiding officer of the court. So we'll have the presiding magistrate or judge sign this, sign and seal it. When we talk of sealing, we talk of the court seal. So sign and sealed, or by such other officer as the High Court may from time to time by rule direct. So these are the requirements as to form of the summons. It has to be in writing. It must be issued in duplicate. It must be signed and should bear the seal of the court that is issuing it. So subsection 2 says, every summons shall be directed to the person summoned and shall require him to appear at a time and place to be therein appointed before a court having jurisdiction to deal with the charge, and shall state shortly the offense with which the person against whom it is issued is charged. So we see now the content of a summons. What should a summons contain? The first thing is that it should be indicating the time and place, okay, of appearance. So the time and place of appearance, okay, all right, and it should state the offense that the person is being charged, okay, against. So now section 92 of the codes is on service of summons, and it says every summons shall be served either by a police officer. So in criminal proceedings, a summons can be served by a police officer, an officer of the court issuing it, okay, or by such other person as the court may direct, and shall, if practicable, be served personally on the person summoned by delivering or tendering to him one of the duplicates of the summons. So in as compared to the civil procedure, the process server is the one who serves a summons, okay, who serves the defendant the summons. Here we see that a police officer normally is first and foremost commonly serving this document of appearance, as well as officer of the court who is issuing it, or by any person the court may direct. And it is recommended, if possible, to have the summons served on directly to the person, okay, by giving him one of the duplicates, because we see that we saw that you have to have the summons issued in duplicate. So you have two copies, you give one of them, you hand it over to the person. Subsection 2, every person on whom a summons is so served shall, if so required by the serving officer, sign a receipt therefore on the back of the other duplicate. So this shows that the person received the summons, all right? They will sign if required on the back of the duplicate, the copy that will remain with the officer, the serving officer. Section 93, service when a person summoned cannot be found. So what happens when a person who is being summoned is nowhere to be found? Where a person summoned cannot, by the exercise of due diligence, be found, the summons may be served by leaving one of the duplicates for him with an adult member of his family, or with his servant residing with him, or with his employer, and the person with whom the summons is so left shall, if so required by the serving officer, sign a receipt therefore on the back of the other duplicate. So if the person cannot be served directly, okay, the summons can be left with their family member, okay, their wife, their husband, their mom, their dad, their uncle, all right, or a servant residing with him, okay, or with his employer. And these people, either of these people is going to sign on the back of the remaining duplicate, the one that remains with the officer. Now, section 94, procedure when service cannot be effected as before provided. Now, if service in the manner provided by sections 92 and 93 cannot, by the exercise of due diligence, be effected, the serving officer shall affix one of the duplicates of the summons to some conspicuous part of the house of the accused, okay, or homestead in which the person summoned ordinarily resides, all right, and thereupon the summons shall be deemed to have been duly served. Now, I am aware of changes in the civil procedure as relating to service of summons, and now we have an amendment in the civil procedure allowing a person to serve through WhatsApp. So you can serve someone through their WhatsApp account. You can serve them through their email, all right, and that service will be effected, all right. So that is the electronic service or service through electronic devices. Here in the criminal code, so far I see no such amendment. I don't know if there has been any change so far, but I will have to check that one out. Service of electronic service of summons. I'm just making a note here so I can check later. So so where you cannot find the person to serve them directly, or their family, or their employer, you will affix as a serving officer one of the duplicates of the summons, maybe in the marketplace somewhere in the town square somewhere where you know can be okay, what am I saying? I'm sorry. Conspicuous doesn't mean just anywhere, not in a marketplace. It has to be on the house that is known to be the house of the accused, or the homestead, okay, where he resides ordinarily. What am I saying? So Section 95, service on servant of government, where the person summoned is in the active service of the government. The court issuing the summons shall ordinarily send it in duplicate to the head of the office in which that person is employed. Okay? And the head shall thereupon cause the summons to be served in the manner provided by Section 92 and shall return it to the court under his signature with the endorsement required by that section, and the signature shall be evidence of the service. So when it comes to public servants, okay, you can serve the summons through the head of the department, all right, in that government uh, uh, office or whatever it is, and they'll have to resend a copy that they have signed as endorsement, all right, that as evidence that they have received or service has been effected. Now, Section 96, service on a company. Service of a summons on an incorporated entity or other body corporate may be effected by serving it on the secretary of that company, the local manager, or other principal officer, all right, of the corporation, or by registered letter addressed to the principal officer of the corporation at the registered office of the company or body corporate. And in the latter case, service shall be deemed to have been effected when the letter would arrive in ordinary course of post. All right. So service on a company can be done either by showing up in the company and giving the summons or handing it over to the secretary of the company, or any local or a local manager of that company, or other principal officer. And where it's not by hand delivery, it can be done through post, okay, by a registered post, and it shall be deemed to be effected or served when it arrives, all right, through ordinary course of post. Now, Section 97, service outside local limits of jurisdiction. When a court decides that a summons issued by it shall be served at a place outside the local limits of its jurisdiction, it shall send the summons in duplicate to a magistrate within the local limits of whose jurisdiction the person summoned resides or is to be there served. So we see that all magistrates, all right, are restricted by jurisdiction, by the local limits of their jurisdiction. So any summons, for it to be effective outside the local limits of jurisdiction, it shall have to go through the magistrate who is not residing, who is within the local limits of whose jurisdiction the person is to be served. All right. So if when it comes to jurisdiction, we know all these things. We know that when it comes to a district magistrate, the jurisdiction is geographical, limited to the district, all right, that they serve, or in the case of in the case where the Chief Justice, or is it the Judicial Service Commission, will decide to join several districts or two districts to be served by one magistrate. So the jurisdiction for District Magistrates Court Class 1 is geographical, limited to the district, as well as we have pecuniary jurisdiction, limited to the amount of fines a magistrate can give. In the case of a district magistrate class 1, they can give fines of up to 20,000 shillings, but not exceeding 20,000 shillings, or give imprisonment up to 7 years. When it comes to district magistrate class 2, we have them giving up to, is it 2 years if I'm not wrong? Just a minute. So district magistrate class 2 will give up to 2 years, yes, with 10,000 shillings. Did I say this right? Yeah, that is right. All right, so we see that everything is already stated in the code. Nothing is left out regarding jurisdiction. So where maybe DM1 wishes or DM2 wishes to effect summons and the person is found in the jurisdiction of DM1, they will simply just have to send and make sure that the district that is or DM1 and DM1 but in different districts, they'll still have to send the summons through the magistrate in the local limits of whose jurisdiction the person they are seeking to appear before the court resides. That is very simple. Now moving on to section 98, proof of service when serving officer is not present. Now where the officer who has served a summons is not present at the hearing of the case and where a summons issued by a court has been served outside the local limits of its jurisdiction, all right, an affidavit purporting to be made before a magistrate that the summons has been served and a duplicate of the summons purporting to be endorsed in the manner herein before provided by the person to whom it was delivered or tendered or whom it was left shall be admissible in evidence, and the statements made therein shall be deemed to be correct unless and until the contrary is proved. So where the person, the officer, the serving officer is not present during the hearing, okay, to give evidence of service of summons, and where this service has been has been issued by a court outside the local limits of its jurisdiction, an affidavit in support is to be effected or given, all right, before the magistrate that the summons has been served, okay, and the duplicate of the summons purporting to be endorsed, the one that has been signed on the back, is going to be showing evidence of receipt is going to be provided by the person who endorsed it or who signed it, showing that they have received. So both the duplicate copy, that is the executed duplicate copy, as well as the affidavit will be admissible as evidence of service. This is the affidavit of service. And that is, I believe, in civil procedure, once a process server has served, they normally have this affidavit of service. But I don't know why in the criminal procedure it's only applicable when the summons has been served outside the local limits of the jurisdiction and when the server is not present. Now, moving on. The affidavit mentioned in this section may be attached to the duplicate of the summons and returned to the court. So this affidavit we have mentioned is accompanied by the summons that has been executed or signed. All right, so now we move on. Section 99, power to dispense with personal attendance of the accused person. Now, subject to the following provisions of this section, whenever a magistrate issues a summons in respect of an offense other than a felony, he may, if he sees reason to do so, and shall, when the offense with which the accused is charged is punishable only by fine or imprisonment not exceeding 3 months, or by fine and such imprisonment, dispense with the personal attendance of the accused. If the accused pleads guilty in writing or appears by an advocate. So where the accused person is charged with an offense that is punishable only by fine, this could be a misdemeanor, all right, punishable only by fine or by fine or imprisonment not exceeding 3 months. Yeah. So it's not necessary for the accused, it's not a must for the accused to enter appearance. So the magistrate, all right, can simply dispense with the accused appearance, okay, if the accused pleads guilty, that is. Of course, if he pleads not guilty, he will be called to enter defense. So the accused pleads guilty in writing or appears through an advocate. Now, the magistrate trying a case may, at any subsequent stage of the proceedings, direct the personal attendance of the accused, and if necessary, enforce his attendance in the manner hereinafter provided. Okay. But no such warrant shall be issued unless a complaint or charge has been made upon oath. All right. So we have that at any time during the proceedings, even after the magistrate has dispensed with the accused appearance, they can call on the accused to show or enter appearance, okay? But they'll only issue a warrant, okay, where the complaint or charge was given under oath. Now, subsection 3, if a magistrate imposes a fine on an accused person whose personal attendance has been dispensed with under this section and the fine is not paid within the time prescribed for payment, the magistrate may forthwith issue a summons calling upon the accused person to show cause why he should not be committed to prison for such term as the magistrate may specify. And if the accused person does not attend upon the return of the summons, the magistrate may forthwith issue a warrant of arrest and commit the person to prison for such term as the magistrate may fix. So, where the magistrate imposes a fine, we said that where in a case of misdemeanor and the offense is finable, if that's a word, and the magistrate has imposed the fine, and the fine is not paid by the accused in the time that is required or prescribed, the magistrate has the power to call or summon the accused again, calling the accused to show cause why he should not be committed to prison. And if the accused now absconds or does not enter appearance or reply to the summon, all right, there'll be a warrant of arrest issued to apprehend him and imprison him, all right. Subsection 4, if in any case in which under this section the attendance of an accused person is dispensed with, previous convictions are alleged against that person and are not admitted in writing or through that person's advocate, the magistrate may adjourn the proceedings and directs the personal attendance of the accused, and if necessary, enforce his attendance in the manner provided in this part, hereafter in this part. So, and the cost of any adjournment will be borne by the accused. Now, we see that when the accused is not required to be present and his appearance is dispensed with, that can only happen in the case of uh, uh, misdemeanors, okay, where the accused has pleaded guilty in writing and appears through his agent, all right, and where the fine has been given and he doesn't pay, we see that the magistrate can summon him back, okay, so fresh summons will be issued calling him to show cause why he shouldn't be in prison for failing to pay the fine in the time required, and if he does not answer or respond to the summons by entering appearance, the warrant of arrest will be issued to apprehend him and imprison him. Now, in any case where the attendance of the accused is dispensed, previous convictions alleged against that person have to be admitted. And if they are not admitted in writing or through his agent, the magistrate will adjourn the proceedings and direct that the accused be present. All right. So we see that admission in writing is very it's necessary to dispense with the accused appearance or attendance in during hearing of the case. Now we move on to warrant of arrest. Now under section 100 of the code, warrant after issue of summons. Now, notwithstanding the issue of a summons, a warrant may be issued at any time before or after the time appointed in the summons for the appearance of the accused. So, yeah, that is self-explanatory. Section 101, warrant on disobedience of summons. Now, if the accused fails to enter appearance in response to a summons, what happens is a warrant will be issued to apprehend him. Okay? But no warrant of arrest shall be issued unless the complaint or charge accusing the accused has been made upon oath. All right. So that is the requirement for issuance of a warrant to apprehend an accused and bring him before the court. Now, section 102, form, content, and duration of a warrant of arrest. What is the form of a warrant of arrest? What is the time or period? And what is the content? Every warrant of arrest shall be under the hand of the judge or magistrate issuing it and shall bear the seal of the court. So it will be handwritten by the magistrate. It's not typed and will bear the seal, all right? Seal of the court that has issued it. Every warrant shall state shortly the offense. So there is like a statement of offense with which the person against whom it is issued is charged and shall name or otherwise describe that person. So the person will be named or described where the name is not known and shall order the person or persons to whom it is directed to apprehend the person against whom it is issued and bring him before the court issuing the warrant or before some other court having jurisdiction in the case to answer to the charge. Okay, so it's very simple. A warrant of arrest needs to be in the handwriting of the judge or magistrate. It shall also be signed and bear the seal of the court that is giving it. The warrant of arrest is issued, okay, in the name of the person who is whom it is to be effected, against whom it is to be effected, and that or in the case where the name is not known, it should describe the person. Also, it will state the offense that the person is being charged with, all right, and shall order the person or the officer or the serving officer to apprehend or arrest the person against whom it is issued and bring him before the court to answer to the offense or charge. Subsection 3, a warrant shall remain in force until it is executed or until it is cancelled by the court. So a warrant is active unless it is effected, all right, or cancelled. Now, section 103, court may direct security to be taken. Now, as a court issuing a warrant for the arrest of a person in respect of an offense other than murder, treason, or rape, may direct by endorsement on the warrant that if the person executes a bond with sufficient sureties for his attendance before the court at a particular time and thereafter until otherwise directed by the court, the officer to whom the warrant is directed shall take the security and shall release on bond or bail. All right, the person will be released on bail or bond. Now, a court issuing a warrant for the arrest can take security and release the person on bond so that pay, so that they attend the hearing when they are free and not in custody or not in remand for that matter. Now, this is self-explanatory. We have seen this in movies and series. Now, we have seen that there's an exception for certain offenses like murder, treason, or rape, which are in this case not considered bailable. Murder, treason, rape. Now, the endorsement shall state the number of sureties, the amount in which they and the person for whose arrest the warrant is issued are to be respectively bound, the time at which he is to attend before the court. So, in the endorsement on the warrant, it will contain the number of sureties, or in this case, guarantors, who will guarantee that the person appears in court, failure to which there will be an amount which is held as security by the court. Okay. In case of default, the amount is defaulted or is acquired by the court. Okay, is not returned to the accused. All right, it will also contain the time at which he is to attend before the court. So time, number of sureties, and the amount that will be bound. Now, whenever security is taken under this section, the officer to whom the warrant is directed shall forward the bond to the court. So, all right. Moving on, section 104, warrants to whom directed. A warrant of arrest may be directed to one or more police officers, or to one police officer and to all other police officers of the area within which the court has jurisdiction, or generally to all police officers of the area. So a warrant of arrest will be directed either to one police officer or several police officers or all of them in that area, provided that a court issuing a warrant may, if its immediate execution is necessary and no police officer is immediately available, direct it to any other person or persons, and such person or person shall execute the same. So where it is of urgency, okay, that the person should be arrested immediately and there's no police in sight or available, any person can be directed by the court to effect the warrant. When a warrant is directed to more officers or persons than one, it may be executed by all or by any one of them. Yeah, okay. So we move on, section 105, warrants may be directed to landholders. Now, a magistrate empowered to hold a subordinate court of the first class, that is DM1, district magistrate class 1, resident magistrate, senior resident magistrate, principal magistrate, senior principal magistrate, chief magistrate. They may direct a warrant to a landholder. Okay. Farmer or manager of land within the local limits of his jurisdiction for the arrest of an escaped convict or person who has been accused of a cognizable offense and has eluded pursuit. Okay, so where it comes to the attention of the magistrate that a person has escaped, okay, a person who has been accused of a cognizable offense. We said a cognizable offense is an offense which you can arrest without warrant. Okay. All right. So where a person has escaped in and is hiding in a piece of land that belongs to someone, a landholder, a farmer who is there or manager of the land, all right, will receive a warrant, all right, to effect the arrest of an escaped convict. This is as someone who's already been convicted or someone who has been accused, okay, and is trying to elude uh, the arrest, okay. Now, subsection 2, the landholder, farmer, or manager shall acknowledge in writing the receipt of the warrant and shall execute it if the person for whose arrest it was issued is in the land or enters on his land or farm or the land under his charge. Moving on, subsection 3, when the person against whom the warrant is issued is arrested, he shall be made over with the warrant to the nearest police officer who shall cause him to be taken before a magistrate having jurisdiction unless security is taken under section 103. Now, the person who is effecting the arrest, remember this is a civilian who is arresting another civilian. In this case, we saw that or we know that under criminal procedure, a civilian can arrest someone who is accused or charged with a crime, but they have to report to the nearest police officer. So the system or the process is the same. If it's a police officer who is making the arrest, they report back to the police station to a superior officer in the station, or they go to the magistrate. In this case, when a civilian is affecting the arrest, they have to go to the nearest police station, all right? That is what normally happens. Now, the same is also under section 105. All right, so moving on. Moving on. Section 106, execution of warrant directed to police officer. A warrant directed to a police officer may also be executed by another police officer whose name is endorsed upon the warrant by the officer to whom it is directed. So if a police officer's name is not on the warrant, okay, but the officer needs another officer, okay, needs him to effect the arrest, they will endorse his name. Okay. Section 107, notification of substance of warrants. The police officer or other person executing a warrant of arrest shall notify the substance thereof to the person to be arrested, and if so required, shall show him the warrant. We've seen this in movies and series where the person says, "What am I being charged with? Okay, what did I do?" But we know that it is also the right of the arrested person under Article, is it 49? No, is it 50 of the Constitution, that the person is read their rights to remain silent. Anything that they'll say will be used against them. They will also be told what they're being arrested for, okay? The police officer who is executing the warrant will tell the person the substance of the warrant, which we saw when we discussed warrants and their content. We said a warrant will contain the offense with the person is being charged with and his name or description. Okay, so that is the content that will be told to the accused as he's being arrested. And if required by the accused, he wants to see the warrant and see if it bears the seal of the court or is signed. The officer effecting the arrest will provide or show the warrant. Section 108, person arrested to be brought before court without delay. The police officer or other person executing a warrant of arrest shall, subject to the provisions of Section 103 as to security without unnecessary delay, bring the person arrested before the court before which he is required by law to produce that person. So the police officer or the person executing or effecting a warrant of arrest must quickly bring the person arrested before the court. Okay, this also is what we discussed in our last or previous video when we talked about remand. When a person is arrested, they can only be remanded for 24 hours before they are brought before the court or brought before a magistrate. This 24-hour period is very, very important because if someone is remanded for for an exceeding time beyond 24 hours, actually someone can apply for can succeed with a claim of illegal detention. Okay, illegal detention of the person through habeas corpus application, if I'm not wrong. Habeas corpus application is done through chamber summons with just a minute. My memory is acting up, but I hope it won't during the exams. It will serve me. All right. Yes, with a supporting affidavit. So we have an application of habeas corpus in chamber summons, where you state the grounds based on, all right, the grounds that you are making the application. And mostly the first ground is that the applicant has been illegally detained. Okay, where you indicate the period. Alright, so with a supporting affidavit. So that is what we have as far as a habeas corpus application is concerned. So 24 hours is the period required by law on a business day. 24 hours. If you are arrested on a Friday evening, I'm sorry, because you will have to stay over the weekend and appear or be arraigned in court on Monday morning. So don't get arrested on a Friday evening. So moving on, Section 109, where a warrant may be executed. A warrant of arrest may be executed at any place in Kenya. Any place. Okay, any place in Kenya. This is interesting because previously we saw that a magistrate who is seeking to arrest a person outside the local limits of jurisdiction will need to go through the magistrate in whose jurisdiction the accused resides, okay, or is found. Okay, I really don't understand, but let's just move on. Maybe this is something we'll understand as we keep on reading. Excuse me. Section 110, forwarding of warrants for execution outside jurisdiction. When a warrant of arrest is to be executed outside the local limits of the jurisdiction of the court issuing it, The court may, instead of directing the warrant to a police officer, forward it by post or otherwise to a magistrate within the local limits of whose jurisdiction it is to be executed. Now, this is exactly what I had in mind as in my thoughts, and we have that under Section 110, where a magistrate is seeking to arrest someone outside the local limits of jurisdiction. Their jurisdiction, for example, if the person who is to be arrested is in Lamu district, okay, and the magistrate wishes to the magistrate who is issuing the warrant is in Kilifi, let's say, is Kilifi a district or Mombasa? I don't know. So they have to forward the warrant to the magistrate in Lamu. Okay. This can be done by post or given maybe to an officer to deliver it to the magistrate. Now, the magistrate to whom a warrant is so forwarded shall endorse his name thereon. So the magistrate in Lamu will endorse his name, and if practicable, cause it to be executed in the manner herein before provided within the local limit. So it is the magistrate who is in Lamu, or in this case, the magistrate who is in the jurisdiction or the locality of where the accused is supposed to be found or is found, is the one who's going to execute the arrest. So he'll arrest, then bring the person over to the requesting magistrate. Okay, so he'll be arrested by the magistrate who is nearest, okay, to the accused. All right. Now, Section 111, warrant directed to police officer for execution outside jurisdiction. So when a warrant of arrest is directed to a police officer, is to be executed outside the local limits of the jurisdiction of the court issuing it, he shall take it for endorsement to a magistrate within the local limits. So I said it's the same thing. The magistrate who is requesting the arrest can either send the warrant by post to the requested magistrate, or they can give it to a police officer to hand deliver it, okay, to travel to that place or to go there with the warrant, requesting the endorsement by the requested magistrate. Okay, so the magistrate shall endorse his name, okay, and the endorsement shall be sufficient authority to the police to whom the warrant is directed to effect it within those limits or within that district. And the local police officer shall, if so required, assist that officer, the one who is requesting or the one who is traveling to that place to execute the warrant. So it's all coordinated, and there's collaboration here between the officers in that jurisdiction and those in the requested jurisdiction in effecting the arrest. Okay, so whenever there is reason to believe that the delay occasioned by obtaining the endorsement of the magistrate within the local limits of whose jurisdiction the warrant is to be executed will prevent its execution, the police officer to whom it is directed may execute it without endorsement in any place outside the local limits of the jurisdiction of the court. So where there is delay, okay, that will be occasioned by the police officer having to go to the magistrate for his endorsement, he is allowed for this reason, okay, to apprehend without endorsement. So where we see, for example, if the police officer is to go to the court and get the magistrate's endorsement, maybe the accused will run. Maybe the police got wind that the accused is hiding in a particular place. or is trying to travel outside the jurisdiction of that place, maybe outside the country or somewhere to another place that would, delay the arrest, the police can just simply go and arrest without endorsement. Now, Section 112, that is procedure on arrest of person outside the jurisdiction. When a warrant of arrest is executed outside the local limits of the jurisdiction of the court by which it was issued, the person arrested shall, unless the court which issued the warrant is within 20 miles of the place of arrest or is nearer than the magistrate within the local limits of whose jurisdiction the arrest was made, or unless security is be taken before the magistrate within the local limits of whose jurisdiction the arrest was made. Okay, so where the court that is nearest to the accused is the court where the accused has been arrested, that is where the accused will be produced. Okay, if the if the court that is issuing the arrest is very far away, that is one of the reasons. Okay, or security is taken. Okay, then they will not be produced before the magistrate within whose local limits of jurisdiction the accused was apprehended. Now, the magistrate shall, if the person arrested appears to be the person intended by the court which issued the warrant, direct his removal in custody to that court, provided that if the person has been arrested for an offense other than murder, treason, or rape, and is ready and willing to give bail to the satisfaction of the magistrate, or if a direction has been endorsed to get his security or security, and the person is ready to give security, okay, the magistrate shall take the bail or security as the case may be, and shall forward the bond to the court which issued the warrant. So this is self-explanatory. The person will be transferred to the court that issued the warrant once he's been arrested and produced. Once he's been arrested by the magistrate that has endorsed the warrant in the foreign not foreign, in the jurisdiction, okay, apart from the jurisdiction of the court that is issuing the warrant, this person is going to be produced or transferred to the court there where the warrant was issued, provided that the person has been arrested for an offense that is bailable. He's ready and willing to give bail or security, okay, and the court that the court that is actually receiving this security is going to transfer the same to the court with jurisdiction, or the court that issued the warrant. Nothing in this section shall prevent a police officer from taking security. So a police officer can also take security, okay, under section 103. Now, section 113, irregularities in warrants. An irregularity or defect in the substance or form of a warrant, and any variance between it and the written complaint or information, or between either and the evidence produced on the part of the prosecution at a trial, shall not affect the validity of any proceedings. Like we said, this is similar to the section previously we talked about. Any defect present in either the warrant or charge is not going to bar the proceedings from taking place, because there's this whole principle of substance over form, that justice should not be prevented just because of technical irregularities, okay, or irregularities in procedure. So an irregularity or defect in the form of a warrant of arrest, and any difference maybe in the form in the warrant as compared to the complaint, or between either the evidence on the produced on the part of the prosecution at trial shall not affect the validity of any proceedings at or subsequent to the hearing of the case. But if a variance appears to the court to be such that the accused has been thereby deceived or misled, the court may, at the request of the accused, adjourn the hearing of the case to some future date, and in the meantime remand the accused or admit him to bail. And nobody wants to be remanded. Anyway, so this is what I'm saying. Any defect in either the charge or warrant is not gonna be a bar to the proceedings, unless if it appears that the variance is of a nature as to have deceived the accused or misled him. The court can adjourn the hearing to some future date, and the accused will be remanded or released on bail. Okay, in the meantime. Now let's just look at miscellaneous provisions, then we take a break. Now, miscellaneous provisions regarding processes. Section 114, power to take bond for appearance. Where a person for whose appearance or arrest the officer presiding in a court is empowered to issue a summons or warrant is present in court, the officer may require the person to execute a bond with or without sureties for his appearance in that court. Alright, so section 115, arrest for breach of bond. When a person defaults bond, okay, that is, they abscond or do not appear, okay, as they have agreed to do so, the officer presiding may issue a warrant of his arrest. So someone who defaults or absconds, all right, does not appear, they forfeit their bond, okay, and they are arrested. Now, 116, power of court to order prisoner to be brought before it. Where a person for whose appearance or arrest a court is empowered to issue a summons or warrant is confined in prison, okay? Within the local limits of the jurisdiction of that court, the court may issue an order to the officer in charge of the prison requiring him to bring the prisoner in proper custody at a time to be named in the order before the court. So the person can be produced, okay, by an order made by the court, all right? Yeah, in order to answer to the charge. Now, the officer so in charge and receipt of the order shall provide for the safe custody of the prisoner during his absence from the prison. All right, so the person who is, let's say it's a police officer who receives an order to produce an accused who is in remand, okay, before the court, or who is in custody before the court, they shall ensure their safe transport to the court and their safe production. Section 117, provisions of this part generally applicable to summonses and warrants. The provisions of this part relating to a summons and warrant and their issue, service and execution shall, so far as may be, apply to every summons and every warrant of arrest. And that is what we will stop here, okay, because we have done a good job so far. 89, from sections 89 to 117, and the next time we'll continue from such warrants and move on as fast as we can. So let me just recap quickly. Today we looked at making of complaints or how to institute criminal proceedings, and we say They can be done under Section 89 through a complaint or a charge that is made before a magistrate, and the person is and the magistrate, okay, will issue a warrant to arrest them where the complaint was made an oath, or summon them to appear before them. Okay, all right. The person who is being the person who has been brought before the magistrate or has been arrested, okay, and brought before the magistrate, the magistrate will require the drawing up of a charge. So the magistrate will draw up a charge and sign it. The charge will contain the statement of offense and okay, and the magistrate okay, what is going on here? Let me just go back quickly. A complaint is an okay, a criminal proceeding is instituted by way of complaint to the magistrate directly or through a charge, that is where the person is arrested and brought before the magistrate to answer for a charge. And in this case, the magistrate draws up the charge, okay, and the charge is signed by him. Now, then the magistrate issues a summons or warrant where he receives a complaint. That is another way. He receives a complaint, so he issues a summons or warrant. A warrant is to arrest or apprehend the accused and bring him before the court. A summons is to require his appearance. Now, a warrant can only be issued in the first instance where the complaint that the magistrate received was made under oath, and only then, not in any other situation. We moved on and looked at the process to compel the appearance of the accused, and we looked at the summons, what it contains, and the form. We said it has to be in writing, it must be in 2 copies or duplicate, must be signed by the magistrate, and must bear the seal of the court. Those are the conditions of a valid warrant of a valid summons. Now, service of summons is done either by a police officer, we say, officer of the court, or any person the court may direct, and should be served personally, okay, to the person, okay. And when the person receives the summons, they will sign or endorse their name on the back of the duplicate, the other form that will remain with the serving officer. This is to be evidence of receipt of the summons. Now, what happens? We looked at what happens when the person cannot be found. We say the summons will be served to the family member or employer, or the maid or servant or anyone working under the person to be served. And and that person who receives will also endorse on the back of the duplicate that will remain with the officer as evidence of receipt. Now, we looked at procedure where the service cannot be effected, okay, where the person cannot be found to be served personally, or where the family, the employer cannot be found. What happens is the serving officer will simply affix or glue or whatever, post the summons on the house that the person ordinarily resides in, and that will be deemed to have been, the summons will be deemed to have been served. We looked at service on servant of government and said that where a public servant is to be summoned or served with summons, it will be done through the head of the department they are working at, the head of the government department. So that head will be given the summons, and they will return the endorsed duplicate one as evidence of receipt with his signature appended. Now, we looked at service on a corporate entity. We said it can be when a company is being summoned to appear before a criminal court, they are going to the summons can be served to the secretary in the company, to the local manager, or to some principal officer, or who is officer of the company, or it can be done through a registered post office address, and it will be effected when it arrives. Okay. We looked at service outside the local limits of jurisdiction, and we said that when a court desires to summon someone outside the limits of jurisdiction, it will send the summons in duplicate to the magistrate. So always know that magistrates are limited by their local limits of the jurisdiction they are in, okay, or they serve. So if they want anything, including summoning or arresting any person outside the local limits of the jurisdiction, they must go through the magistrate that is in whose jurisdiction the accused they intend to arrest or someone is found. That is the only way, and the magistrate in that place will endorse the warrant or summon. Now, we also looked at proof of service when serving officer is not present, and we said that an affidavit of service is going to be admissible as evidence accompanied by the duplicate signed or endorsed copy of the summons. All right, that is the evidence that is going to be admissible to show that service has been effected. Service of summons has been. Now, we looked at the power to dispense with an accused. We say that it's not necessary for an accused to to be present during the hearing of a misdemeanor where an offense is not a felony and is finable, or where the imprisonment is not more than 3 months. We say that the accused, in order for this to happen, the accused has to plead guilty in writing, okay, or where the accused is being represented by his agent. The magistrate trying a case, we say, at any subsequent stage can order for the attendance of the accused. Okay, all right. Now, we also discussed warrants of arrest, and we said that a warrant is issued, okay, at any time before or after the time appointed in the summons for the appearance of the accused. So this happens, of course, where the accused does not reply or show up to the summons to have him appear before the court. So it can, and a warrant can happen anytime before or after the time appointed in the summons. We also looked at warrant on default of summons or lack of appearance. We say that no warrant can be issued unless the complaint has been made under oath, the complaint that is charging the accused. So we looked at the content and form of a warrant, and we say that a warrant must be handwritten by the judge or magistrate. It must also bear the seal of the court. It must, we say, contain the statement of a short statement of the offense against whom the accused is charged, and will name the accused, and if the name is not known, okay, it will describe the accused. Now, we looked at where the court can direct for security to be taken, and for the offenses other than murder, treason, and rape, a person can, the officer who is the police officer can get security, okay, from the person he's arresting, and that security will contain the guarantors or sureties, the number of sureties, that is the amount which is the accused is to be bound in case he defaults, and the time at which he is to attend before the court. and the officer who is arresting will forward the bond to the court. He will not keep it. We looked at warrants, and we said who it's going to be directed to. And we say it can be directed to a police officer, one or several, or all of them in one area. And the warrant will be effected if any of them fulfills it. Now, warrants may be directed to landholders where a person, a convict, has escaped and is residing in your land and you are the property holder. So it's going to be directed to you to effect the arrest, or to a farmer on that land, or to someone who is a manager and is a caretaker of that property, okay? And if this person, who is of course a civilian, affects the arrest, the first thing they should do is go to the nearest police station with the arrested person, okay? Execution of warrant directed to a police officer. We say that a warrant directed to a police may be executed by another police if he endorses the name, okay, of the person to carry out the arrest. Notification of substance of warrant. We say the police or any person executing a warrant shall notify the substance to the person. They will read the offense. They will read the offense the person is being charged with to the person, and also show him the warrant if he requests. Okay, so if you are finding yourself getting arrested, don't just put your hands out, let's go. Just take notice you are being read your rights, and you know what you are being charged, and if you require, you see the warrant. The first thing when you see the warrant, you want to look at the signature appended by the magistrate, and the seal of the court has to be there. Now, I say that because there have been instances where people masquerade as police officers and they try to arrest someone. Uh, and it turns out they're not really police officers. They're just masquerading for some, serious corruption activities, or to kidnap the person, or solicit money from them. So you want to be open, you want to be alert. Now, person arrested, we say, should be brought before the court within 24 hours. That is the rule. If the officer requires time, an extension of time for the person to be in remand, they will have to apply. And I remember the application for extension of time. What was it on the section? Yeah, it will be in writing. If the officer wants more time, he will apply in writing, and the application shall be supported by an affidavit sworn by the police officer. Okay, but it doesn't say which application is it. Uh, uh, I don't know which application this is. And the application shall contain an affidavit, shall be accompanied by an affidavit, which will say the offense that the accused is charged, the nature of the evidence on which the suspect has been arrested, the inquiries that have been made by the police in relation to the offense, and further inquiries proposed to be made by the police. The inquiries, investigation, the reasons necessitating the extension of time. All right, so we looked at many interesting things, and we said a warrant may be executed at any place in Kenya. We also said that a police officer, we said that a warrant can be forwarded for execution outside the jurisdiction if the magistrate endorses his name, all right? And where there is delay, okay, that is gonna be resulted if the officer goes to the magistrate for endorsement, they will go ahead and arrest anyway without endorsement. We also looked at procedure on arrest of person outside the jurisdiction. We say that the person who will be the accused will be produced before the nearest court. If it's the court that issued the warrant, well and good. If it's not, the one that is nearest. We also say that unless the person, okay, and once the magistrate receives that person in court, they will transfer them. Okay, direct his removal in custody to that court, the one that issued the warrant. All right, that is for the offenses other than rape, treason, or murder, and he is ready to give bail. Now, we said any irregularities in warrant are not going to bar the proceedings, okay? But if it happens that the accused has been deceived or misled because of a difference in the warrant, warrant and evidence or information or complaint received, then the court will postpone or adjourn the hearing at a future date, and in the meantime the accused will be released on bail, or the accused will be remanded or put in custody. Power to take bond, we say the officer who's arresting has power to take bond, or the judge or magistrate has power to take bond or ask the accused to execute a bond with or without sureties. Arrest for breach of bond, we say that when someone defaults or absconds appearance, the magistrate will issue a warrant to arrest them, and of course the bond will be defaulted. The money that they have given as security will go to the court. Now, power of court to order prisoner to be brought before it. A person for whose appearance or arrest a court is empowered to issue a summons or warrant is confined in prison. If somebody is confined in prison, the court can order for their production. Okay. Provisions of this part applicable to summons and warrants. And that is our conclusion for today's topic. Thank you very much and have a lovely day.